The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the following program. I'm your host, Joe Neerman, aka Good Logic. Hope you had a phenomenal day today. A day where we actually got some news which relates to our country and our country alone, thank God. Although the news itself was not exactly that phenomenal. It's nice to get back to a little bit more of what I normally do here. So, where to begin? Where to begin? Well, you might have heard that former President Trump has been indicted in several different jurisdictions of criminal charges, one of them being the District of Columbia. You probably heard about that. You may not have known that today was the day that he was supposed to be appearing, or not appearing by counsel, meaning not him personally, but through his attorneys, would be appearing on his behalf before the judge with respect to a motion that was brought by prosecutors who were seeking to silence him, saying the things that he is saying are too dangerous, too terrible, too disruptive, and that they will impact this trial in a way that is prejudicing. I don't know why it doesn't sound right, but prejudicing the potential jury pool. And accordingly, the judge needs to issue an edict, an order, a directive that restricts him from saying things that the government feels may, in one way or another, taint the jury pool improperly. So, this is in federal court in Washington, D.C. No cameras are allowed in federal court, which is very, very annoying. Very annoying. I will tell you that if that trial ever gets underway, I definitely plan on considering going down there for that. That trial, definitely. Yeah. All right. Well, anyway, long story short, in court today, yes, late in China, very China. I am that was very, very China of me. In court today was a gentleman by the name of Roger Parloff, who is a member of an entity called Lawfare, which is a pretty cool name. I happen to like the name. And he provided a thread where he detailed step by step everything that went down today in court. Everything. Now, this is it's not the same thing as a transcript. I searched around for transcript. I wanted to see, can I find something? Can I actually read through the transcript? Because what we're hearing now is third hand. A transcript is really second hand. First hand is being there. Well, first hand, technically, I could probably break this down being as far as fourth hand if I wanted to. But the point being, this is the best we got for now. And it's pretty good. I strongly recommend that you guys follow R. Parloff. If you're on Twitter, R. Parloff. This is the gentleman right here. Did a really great job. Really great job. Senior editor at Lawfare. And you should support Lawfare because they help shed a light on things like this. They have a Substack, and you can support them there and follow them directly if you're so inclined. I'm here to give you my takeaways about what was reported today as coming out of that courtroom. And he starts by saying that I'm in E. Barrett Prettyman U.S. Courthouse this morning. That's the courthouse that I was at when I was covering the Bannon trial. That's the District of Columbia's district court. Did I see the red landslide Louisiana government race? Gives me a little hope. Doesn't seem to be much reporting on it. I covered this 2 nights ago, the day it happened. I announced it. And what was impressive about Landry's win was that he was the AG who ended up winning the governor, was that he was competing against a whole number of different Republicans, and he was able to garner sufficient support to get to 51% in order to not require a runoff against the Democrat. So yeah, now, I mean, it's Louisiana. My take on it was, I don't know how anyone blue ever wins there. No one blue should ever be winning in Louisiana. But then again, I would have said the same thing about Georgia until like 5 years ago. So I guess we got to take small wins. All right, so let's go through this. He says, I'm at E. Barrett Prettyman U.S. Courthouse this morning. Plan is to live tweet for Lawfare the 10 a.m. hearing in USA versus Trump D.C. over government's request to impose gag order on Trump. And he shares here, the parties in this case and their attorneys are prohibited from making or authorizing statements in the media or public settings, including through social media. Well, we'll come back to this. That's the ultimate order that came out. Incidentally, those who want more about the info about Thursday's Garcia hearings before Judge Cannon in the Mar-a-Lago case can either listen here or I'm hoping to have a dispatch up on Lawfare by later today. If you're interested in that, you definitely check that out. I likely will. While we're waiting for the gag order here and start for Judge Chutkan, I'll just mention some things of possible interest about the courthouse. I don't care about this. Neither do you, likely. If you really cared about the courthouse, you would probably know by now. So I will tell you, it's a pretty boring-looking building. He describes it as 1950s classical, stripped classicism. It's with high ceilings and really boring, like just ugly green rugs and ugly green carpeting, not rugs. It's a very boring-looking building. And everything is just very rectangle, very, very rectangle. Okay, so apparently Representative Marjorie Taylor Greene was at the courthouse waiting in line for general public to attend the gag order hearing. To orient people on the law before the hearing begins, the government relies mainly on two SCOTUS cases. One is 1966 case in Shepard v. Maxwell, where the court overturned the conviction of Dr. Sam Shepard. The trial had been the ultimate media carnival. It was a sensational case. Surgeon accused of bludgeoning his pregnant wife to death in suburban Cleveland. Court said judge had power to prescribe extrajudicial statements by any lawyer, party, witness, or court official which divulge prejudicial matters. And you could sort of understand that it's not really fair to have someone just give their narrative out there. I'm trying to view this objectively as an attorney. So you can understand that it's not fair that the state's not allowed to go around talking about what you did. So for the defendant to go out there and start prejudicing, you can understand a perspective of him saying that, like, you can't just go around tainting everything by broadcasting your perspective on things and building that narrative so that it gets cemented in the minds of a jury pool. At the very least, that's the concept behind this. That's the concept behind this case. Government's other main precedent is Dominic Gentile versus State Bar of Nevada. Their government upheld constitution of a rule permitting judge to bar an attorney from making communications that pose substantial likelihood of material prejudice. And as was going to come up during the course of this conversation, just because there are court cases which say you can bar an attorney from speaking doesn't mean that you can bar his client from speaking. That's not the same thing. And if you think about that, and I'll explain to you why philosophically there's a distinction. The only reason that the purpose of free speech is to enable us to express ideas and thoughts. The factual allegations about what happened in any event are less a matter of ideas and thoughts, and that's more a matter of someone testifying and just relating over historical events from their perspective. Still, you can understand that free speech is designed to enable people to get that out. It doesn't necessarily, and we should be very careful before we ever restrict that in any way, shape, or form, because that's really stepping on someone's liberty. if someone is a hired gun to repeat my statements for me, they have less of a, I guess, innate need to express that. It's not part of their fundamental civil liberties to express that. Yeah, I understand they have a fundamental civil liberty to try and go out and make a living for themselves, but it's not part of who they are. So I can understand why we would be less worried about clamping on that third party's speech than on the first party being me. Someone speaking on my behalf, I can understand that's speaking on my behalf is not the same as limiting me from speaking about me or things affecting me. So that's the concept in Gentile, which says that we can be restrictive on attorneys. Trump's attorney says Gentiles should only apply to orders against attorneys, not parties. Trump also cites cases about attempts by judges to directly gag media organizations. We usually can't restrain speech without clear and present danger, which is an extremely high standard. That's the whole point, which we have, like in Brandenburg, that if it's inciting someone to do something, you're creating a clear and present danger. And otherwise, in general, free speech is supposed to be permitted. That's the whole purpose of the First Amendment. There is less law on the subject than you might think, and of course, there's no law about imposing a gag order on a party's leading candidate for the presidency, because that ain't never happened before. That's never happened. There's a Fifth Circuit that did permit one against an elected insurance commissioner. Ooh, same thing, same exact thing. Elected insurance commissioner. And I don't even know what an insurance commissioner is. What the heck is an insurance commissioner? Oh, totally. Gag me with a spoon. Oh. Of course, the one show of yours I miss. It's okay. I'm not upset that you missed the other night. That happens. Federal district courts around the country have come out different ways on these issues, but at least 5 gag orders have been issued against parties in D.C. in recent years. One was issued by Judge Chutkan in USA versus Maria Butina, the Russian agent. Others were issued in cases against Roger Stone and Paul Manafort. And the key thing that we're going to see from Judge Chutkan is she's going to say, I don't care that he's running for president. I don't care that he's running for president, which is ironic because the only reason this case is being brought is because he's running for president. So we'll see some of that doublespeak later on. The screens are now in the media room. There are actually 2 media rooms. Here, there are 2 screens, each of which is split into 4 quadrants, one trained on a judge's bench, 2 others on different parts of the courtroom, and last is for exhibits or witnesses. Now, what he's referring to is when you come into the courthouse, because they actually have what's called, you can come in different entrances that are on opposite sides of the building. I think there's actually a third. I think you could probably come. I'm pretty sure you could probably come in from all 4 directions. But one of those 4 entrances, I don't think anyone ever is able to use. But it would just probably be more for emergencies or for personnel. The public entrance in the Barrett Perryman courthouse. One of them has that, like, right after you come through security, you walk down 20, 30 feet, and there's a room over to your right, which is like a big room with a TV in front, and that's meant for members of the media to go in there and sit there watching on video a screen of, someone who's the feed from the courtroom. Others will actually make it into the courtroom. Like when I went to when I was at the Bannon hearing, so I actually spent most of my time up in the courtroom there, in the actual physical courtroom, taking notes. At a certain point, it was like towards the end of the trial that I actually even first learned of that media room downstairs. And you just see all these different writers for like New York Times, Daily Beast, Daily Wire, like, anyone basically who's interested in a political case is going to sit there and send someone to cover it, and they'll just be taking notes, writing frantically as the trial is going on. So yeah. So anyway, so that's where the media room is. The media room is on the ground floor there, right near the entrance when you come in, which I think is designed to enable them to basically come and go relatively quickly without having to go through the entire building. And because you can't really bring much of your equipment in there. You can bring a laptop in there if you maybe, but beyond that, you can't start reporting from inside the courthouse. So all the reporters are waiting outside the courthouse. And so if someone wants to go and contact their producer or whatever, so they can basically just step right outside to where the rest of their team is waiting for them outside. So here are two screens, each was split into 4 quadrants. On one train on the judge's bench, 2 others on different parts of the courtroom, and last is for exhibits or witnesses. At defense table are Trump's team, John Lauro, Todd Blanche, Greg Singer, Emil Bove, and one additional man who may be paralegal or associate. Bove is a recent addition. He's former head of the National Security Unit of the Southern District of New York, a heavy hitter. Cool. We can change. We can't see the prosecution table at the moment. I suspect that will change. The leads on the motions so far have been Senior Assistant Special Counsels Molly Gaston and Thomas P. Wyndham. We're going to see Molly Gaston as the one who spends most of the time talking. By the way, Lawfare is flooding the zone today. My colleague Hai Minij-Han will write a dispatch which will hopefully publish ASAP if you prefer that format and avoid certain platforms. I definitely want to support Lawfare more because I really like the work that they do. Judge now explaining what motion seeks. Order restricting out-of-court statements. This is what they were asking for. Out-of-court statements prohibiting all parties from making or authorizing statements, including through social media. She actually is discussing a much less controversial subject first. The government wants restrictions on jury survey practices. Judge skeptical we need many restrictions on these. So, Gaston, we were concerned questions in the study might prejudice the jury pool. Now, the reason I think that the government brought this up is I think that this is the empty gesture. This is giving Chutkan an opportunity to do an empty gesture and rule in favor of Trump for the purpose of actually helping the judge look impartial. So basically, there's a whole question as to like whether some of the questions that he might put in the jury and jury questions may be something that will taint the jury. So the state comes up with this empty claim of like, we don't really like some of these questions. We have concerns about some of the questions that they want to ask the jury, knowing they're going to lose on that. But in so losing, they're giving the judge a win toward proving to the public that she's impartial. Because this way, all the media will be like, look at this. You see, she doesn't always, it's not like she's ruling against Trump all the time. She gave him this win here on the on the whole jury. Who cares about that? No one cares about the jury questions. You can always just change the jury question. No one cares. Nobody cares. Trump doesn't really care about that. The government doesn't really care about that. It's like you're in a fight. It's like imagine you're in a dispute with like your most heated rival on earth, okay? And you live 2 houses away from each other, and you both have like a claim about the house that's situated between you as to which of you it belongs to. You both claiming you bought it from your neighbor, and you hate each other. You despise each other. You can't stand each other, okay? And it's you versus Tom. And you find out that the judge is basically Tom's lifelong best friend. And everyone knows that it's Tom's lifelong best friend, okay? That's who the judge is. And you're sitting there and you're like, this guy, every motion, you're losing. So it's like all of a sudden, so your enemy there ends up bringing a motion saying, hey, we want to have a motion that says that you can't have any mailboxes on the block. Like, why would they care about that? Your enemy doesn't care about that. You're not worried about that. You're not thinking about that. But it's an opportunity for the judge to be like, wow, I don't know. I don't think we need to do that. I don't think we need to go that far. You see, I'm being really fair to you. I'm not just favoring Tom. He wanted me to stop you from giving mailboxes. I'm not letting him do that. I don't think that's right because I follow the law. This courtroom is about the law. And that's what I think that this motion is. It's a throwaway motion designed to be lost for the purpose. It's like a loss leader in a supermarket. Sometimes you sell something below cost. You know you're taking a loss on it, but the idea is you're basically trying to promote something else. In that context of a loss leader in the store, it's to get people in the store. In this context over here, it's to buy credibility for Judge Chutkan. That's what it is. But here she is giving Gaston for the state is giving it the old college try as she's trying to get the judge to go along with her on this very important issue about jury survey practices. We were concerned questions in studying my prejudice, the jury pool. Judge Chutkan thinks defense proposals are sufficient protection for a moment, so she's going to deny the government's motion for additional protections, not going to preemptively micromanage survey requirements. Now, move to the gag. Okay, now that we got that out of the way, now that the judge shows how completely impartial she is, let's talk about what everyone really cares about here, which is whether or not we should silence the Republican Party's leading candidate for the 2024 presidential election. Now, move to the gag order issue. Order government seeks is below, which says the parties in this case and attorneys are prohibited. This is what they wanted. This is a lot. You'll submit the if you're a movement and you want to get an order from the court, frequently you will submit a pre-written order, and your objective is to get the judge to sign that order. And you leave a blank space there for the judge to sign, and you fill out what the order should say. And that way you sort of make it easier for the court, and it makes it clear as to exactly what type of relief you're seeking. That's not really where you make it clear, but the point is it's a way of making, if you make things easy for someone to walk down a road, they're far more likely to walk down that road. So this is how attorneys do it for judges. In many courtrooms, it's a requirement that you submit a proposed order. 1, the parties in this case and attorneys are prohibited from making or authorizing statements to the media or in public settings, including through social media, that pose a substantial likelihood of material prejudice in this case. This is so vague and amorphous. This is what makes this so ridiculous, and this is why anytime they're trying to limit free speech, it's what does that mean? A substantial likelihood of material prejudice. What's material? What type of prejudice is material? And what's a substantial likelihood? Do we think for a second that there has been material prejudice? What by things he said previously? Does anyone think that there's been that the state's case has been prejudiced based on things that Trump has said? Really? I mean, who really buys that? Do you think that there's a single juror out there who's like, well, since Trump wrote this on Truth Social, obviously, if I were sitting on his jury, now I'm going to go along with him? That's essentially the concern that the court is trying to address when they go through this very drastic remedy of limiting his basic free speech rights. So such statements include, but are not limited to, statements regarding the identity, testimony, or credibility of prospective witnesses, and disparaging and prospective witnesses. I don't know who's a prospective witness. There could be thousands of them. There literally could be thousands of prospective witnesses. Disparaging and inflammatory or intimidating statements about any party, witness, attorney, court personnel, or potential jurors. You can't say anything disparaging about another attorney. I can't say anything disparaging about any witness. Why not? Why can't he say that that he thinks Brad Raffensperger has a gross nose, or that his face looks like that he was his face looks like that he battled SARS throughout his childhood? I don't care. Whatever the heck he wants to say. That's ridiculous. Inflammatory. And what's inflammatory? Inflammatory to you is not necessarily inflammatory to me, and which may be way less than what's inflammatory to some old woman. Who the heck knows? It's so, all of this is so subjective. I want to just like focus on this for a second here. Substantial likelihood, subjective term. This term here, substantial likelihood, subjective term. Material prejudice, subjective term. Disparaging, subjective term. Inflammatory, subjective term. Intimidating statements. What's intimidating? What's intimidating? If he says, hey, one of the things they talk about later on is if he says, hey, if Barr does this, he's never going to have a spot in my cabinet. If Bill Barr doesn't stop acting like a moron, he'll never have a spot in my cabinet. Is that intimidating, or is he making a statement that he thinks the guy is he's intimidating that he's not going to be able to get a job with him? Or is it intimidating? Have to be physical intimidating? I don't understand anything about this. None of this makes any sense. And it applies to any party, any witness, attorney, court personnel, or potential jurors. Who are potential jurors? Who the heck are potential jurors? Who on the planet is not a potential juror? Seriously, who on the planet is not a potential juror? It's so stupid. So asinine. Where it all began, Mark Say from Alex Jones on iTunes. Well, phew, good for you. Thanks, Tim Cook. Free from speech Tim Cook doesn't like or something, apparently. Sherry Lawlessness says, meanwhile, prosecutors can give half-hour-long press conferences detailing all the wrongdoings of the accused. Seems fair. Yeah, that's true. That's true. As soon as they file their charges, all of a sudden they come out with their statements. It's a great point, Sherry. Great point. I approve. I approve of that super chat. Judge is reviewing the dispute over whether Gentile, the SCOTUS case allowing limits on attorneys, is limited, as Trump alleges, to attorneys. She doesn't seem to think so. Surprise, surprise. She's now commenting on all the things the proposed Trump order does not prohibit. It's just like, it's not really that limiting. It's not that limited. It's really not that limited. It's crazy. This is so insane. Now mentioning that Trump conditions of release already require him to abide by federal laws. He's already required to abide. One is 18 U.S.C. 151, which prohibits attempts to interfere with witnesses, including knowing use of intimidation and harassment. What the heck? What is intimidation and harassment in that context, though? That's not that you say something in public. That's that you go to the person and direct something at them. As long as a witness is foreseeable, attempts to influence him may run afoul of Section 1512. She cites a D.C. Circuit ruling for that. Does not appear Trump has violated conditional release. Oh, phew. Oh, phew. We were worried that by the time this whole thing was over today, she'd be like, he's violated and throw him in jail now. Judge asked Molly Gaston how its proposed order differs from existing conditions of release. Meaning, what do you? Okay, so tell us now. What do you want to tack on? What your whole objective here? Right now it's not signed. If I sign this order, how will that change things for going forward? Assistant Special Counsel Molly Gaston. 2 sources of prejudice government seeks to prevent. 1, derogatory, inflammatory, intimidating statements attacking witnesses not covered by 1512. But risk both witnesses and other witnesses that see that attack. Why? Okay. 2, he said something mean about me. I'm not going to go testify now. 2, trial of case in public. False renditions of evidence, attacks on witness credibility. Judge, so she starts with the first one, talking about intimidating statements. Set aside for a minute subjects and statements. How do you define disparaging and intimidating? Well, that's a pretty good question. Gaston, the dictionary definition. She recites some of those. It's a combination of these things. There can be fair ways to disparage someone. Judge, you use the word fair, and that concerns me, asking court to get involved for a wide variety of statements. Because, let's face it, there's no way that anyone could possibly do that fairly, even if they were so inclined, which to date, it does not seem that she has had that inclination as of yet. But who knows? We're all holding out hope for you, Judge Chutkan. Gaston, the standard here is this is limited to witnesses at this trial. Statements intended to influence the trial. Article in Washington Post by Trump's spokesperson. His intent is to try this case in the court of public opinion, exactly what should not happen. Our proposed order, narrowly tailored, which is, of course, when you're restricting speech, it always has to be narrowly tailored, but narrowly tailored to accomplish that purpose. We're not wedded to these exact words. We know this is hard, but answer cannot be that defendant is permitted to intentionally try this case in court of public opinion and influence jury veneer, meaning the jury pool. Which is, it's so stupid. It's so stupid. And this is what's so aggravating before we go further. What's so aggravating is when he's speaking about these things, he doesn't give a damn about this trial. He's not worried about this trial. He's not thinking about this trial. He's not doing it to try and influence a jury. And they're making it as if, you know why he's doing this? Because he's trying to taint the jury pool. Everybody knows the reason he's doing this is to campaign. And that's something that I did not notice his attorneys saying. That the government here is masquerading as if they believe that his objective is to try and taint the jury. But it's not his objective. We all know the fact here is he's trying to win a campaign. He's trying to win the election president of the United States. That's his primary focus. So to try to twist it as if the reason he's doing it is because he wants to intimidate someone so that they don't testify against him and cause him to lose this case is absurd. It's absurd. People could do something that have a multitude of impacts. There's no reason to think it actually has this impact. And we all know that that's not his primary objective. His primary objective is to make an audience laugh, to make his crowd believe in him so that they'll vote for him. And he doesn't care he's not even trying to target people in D.C. because he knows he'll never win in D.C. The word Trump will be like Mel Gibson at the end of Braveheart, only instead of crying freedom, will suggest the judge sodomized herself. So you can do a better surprise Gomer Pyle than that. You think I can? Surprise. But good catch. That's what I was doing. I grew up as a little kid. Like I remember, like 5 years old, midday reruns of Gomer Pyle were on. My mother used to be like folding laundry, and I'd be like watching it. That's my recollection of my very early childhood. I can even still hear the laugh track in my head. All right. Anyway, returning back now to the topic du jour, which is going through the judge's discussion here. So, narrowly tailored to accomplish that purpose, we're not wedded to these exact words. Now, the reason that Molly Gaston says we're not wedded to these exact words is because when you're counsel here, your objective here is to try and get some form of the relief that you're seeking, and you know that the judge may not go for everything that you're saying, so you're sort of giving your tacit approval that, judge, look, you can change it however you think works best, but we want you to give us some form of this relief. Even if you think some parts of it are not legal or proper, to the extent you can try and mold it as you think would make it legal and proper, we want you to do that. We know this is hard, but the answer cannot be that defendant is permitted to intentionally try his case in the court of public opinion and influence the jury veneer. Judge, what about attempts to publicly praise a witness? What if because you're implying he can't talk about witnesses, which means he can't praise a witness. Gaston, that's what we're trying to get at in paragraph 1A. Bolstering a witness, for instance, is covered. You can say good things. The order has a carve out for a judge to announce without more that defendant denies charges. That's it. Meaning you want me to sign an order which says the only thing that judge could do is that he can come to a rally and if he's talking about events of the day, he can be like, so I'm being tried in Washington, D.C. Can you believe this? Let me tell you about this. I'm not guilty. And that's it. He goes on an interview, and an interviewer says, so about those charges in Washington there, they say that you were basically making false accusations about Ruby Freeman. What do you have to say about that? Because it seems like they're spelling out there in those charges all these terrible things that you did. Not guilty, not guilty, not guilty. That's what he's supposed to do on this campaign. I'm just not guilty. Well, then how do you explain it? I'm not guilty. So you also, this is what he's supposed to be doing on an interview there. And they also say that you went to Michigan and you had people go there and start lying to people there. I'm not guilty. I'm not guilty. I'm not guilty. Well, what about what happened in New York and all that other stuff that was? And what about things that were happening out west, where they say that you were making all these that you intentionally were sending people out there to try and confuse the court out there? No, I'm not guilty. I'm not guilty. They say that you sent out slates of electors. I'm not guilty. I'm not guilty. That's what they want him to do. You can't say anything about it. Everyone in the world knows about these things. Everyone knows these are public records that everyone is talking about. But his whole defense to the public should be like, I'm not guilty. I'm not guilty. I'm not guilty. Plead the fifth. I plead the fifth. This is how he's supposed to be running a campaign. It's outrageous. It's so bloody outrageous. Unbelievable. It would allow the defense campaign. You could say, no, I didn't do crimes and I acted appropriately. This is just, it's like anyone who thinks for a second that is a totally normal way for someone to go out there and campaign, sitting there getting drilled by CNN with questions, and then he should be left saying, not guilty, and like go running away, not guilty. Like, what the heck? What the hell's wrong with these people? Just because and here's the thing. I actually feel as if the purpose for these charges, the primary reason that these charges were brought was so that this order could be issued. The reason that he is actually facing these charges, is so that they can basically try and handcuff him and muzzle him and silence him and say, you can't talk about this, otherwise that you're now going to be in violation of a court order. That, yes, they want to try and tar and feather him. Yes, they want to try and embarrass him. But a very important component of it is, let's make it as difficult as possible for him to be able to campaign by making him be silenced or questioning, can I say this? Am I allowed to say this? And then we'll try to find some moment that we feel that he breached that, and we'll come forward here and say, you breached that, and try and throw him in prison for that too. Try to sanction him for that too. Judge, you're envisioning a different situation than currently exists. Trump attorney Laura, we're in a campaign dealing with content-based political speech. Biden administration is attempting to silence his primary opponent. Judge, let me stop you there. Mr. Trump is a criminal defendant, and he's subject to the rules everyone else is. That's got nothing to do with this. It's got nothing to do with whether or not he's subject. He's not denying that he's subject. The point is that their objectives here have nothing to do with trying to protect the integrity of their case, and is motivated instead by an objective of trying to silence a political opponent. Everyone's complying. Laura says everyone's complying. Judge, everyone's complying. She's very skeptical. She's not buying it. She's not buying it. Laura continues, here these prosecutors want to prevent President Trump from speaking out on issues of the day. The role of prosecutors, appointment of judges, all have political implications. So the judge jumps in with that and says, I want to make sure I'm clear on this recurrent theme. Fact, he's running for president entitles him to make statements that are otherwise unlawful. He can make threats. That's not what he said. That's not what he said. Laura, of course not. And he hasn't made threats. He has restraints on his speech. Do you disagree that those override his First Amendment rights in campaign? He's subject to conditions of release. And of course, any restraints that anyone else has on free speech, of course, that would apply. Laurel says, what we object to is the Biden administration attempt to censor his political opponent. Mr. Trump is entitled to speak truth to oppression. He's entitled to criticize these prosecutors. Here we have a situation with the Biden administration. I know you have a message you want to get out. I don't want to hear campaign rhetoric. It's not campaign rhetoric. No one's trying to talk to you campaign rhetoric. The point is that he should be allowed to talk to others campaign rhetoric. That's what free speech is. That's the point. That's the point of the entire thing you're dissecting here. That's it. That's a critical element to the analysis. It's not that you have to hear campaign rhetoric. It's that he has to be free to express campaign rhetoric to his potential voters. Laura says it's not campaign rhetoric. These prosecutors decide to bring this case in the middle of a campaign, chose to have it inextricably intertwined with a political campaign. Trump is entitled to say these proceedings are unfair. Obviously, that should be. He's abided by your orders. Well, I'm going to take issue with that. Prosecutors haven't presented any evidence of jury taint. Easiest thing to do is put the trial off until after the election. We don't have to rush to judgment. That's the way to deal with it. The judge ain't having none of that. You know that. Judge ain't having none of that. Judge says, this trial will not yield to the election cycle. Very adamant about that. This trial will not yield to the election cycle. Why? Why is it so critical to go through this now? I'm going to have my trial. I'm going to have my trial. Which turns to the state and says, Ms. Gaston, want to ask how this would work. Say I enter this order. Mr. Trump violates restriction. What happens next? Revocation of supervised release? Home detention? Contempt? Should we stick pins in his body? I got places I want to stick pins. Should we get out the thumb racks, the thumb screws? Tie his hands down and because he will say, this is the thumb you use to tweet. This is the thumb you use to press send on Truth Social. Should we actually like clamp something onto his tongue so that when he goes out there the entire time he has to sound like ah, la, 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 la. What do you want us to do, Miss Gaston? The world is your oyster. Tell us what you want. What do you want? Should we throw him in prison? Should we send out? Should we actually hire like decent meme makers for the left? What do you want us to do? Tell us what you want. The world is your oyster. How does it work? What do you have in mind? Sell me on it. Come on, you can do it, Gaston. No one screw up like Gaston. Real hack like Gaston. All right. I hadn't thought that one through. Gaston says, all the options you mentioned are available to the court. They could admonish. They could pursue financial penalties. They could, like in the Stone case, modify conditions of release, bring him back into jail. We'll throw handcuffs on him. We could do all of these things. You can do whatever you want, Judge. The judge wants to know, okay, procedural posture. Because we all know he's going to violate my order. We all know he's going to violate it. So we should figure out here when he violates my order, what are the steps taken procedurally so that we can start doing whatever we want to torture him. Should be an order to show cause, meaning what Chutkin is asking Gaston is when he violates the order, which we know he will, at least in your opinion, which I'm likely to agree with, but you're going to have the opinion that he violated the order. I'm going to agree with you. So the question is, how is this going to be called before the court for me to issue a decision as to, hey, Trump, you violated this order? So should have an order to show cause, which means you would bring a motion by a process called order to show cause, or sua sponte, find a violation, meaning that the next time he's in here, you don't even have to bring a motion, but I could just be like, hey, I was looking online. Sua sponte means of the court's own initiative, spontaneously. So, like, basically, no one even knows that there's any issue, and judge would and they'd be in court, and the judge would be like, I saw an article where Trump said this, and I think that's a violation of my order. So now I'm putting him in contempt. I'm going to issue I'm going to mandate that he be held by the bailiff. So how do you think this should work, Molly? How do you think this should work? Should you come to me, or should I be free to just go out there and scour the internet for anything he says that I don't like so that I can punish him? Gaston, any of those, but that's a hypothetical. Suggest we first get in place an order. Gaston, you're not getting it. Gaston, she's already got in mind the order. She's trying to figure out exactly how to put in the order, what the steps are. You're not getting it, Gaston. You're not getting it. Judge, Mr. Lauro, assuming I issue an order, what would be proper procedural posture for violation? So she's basically saying, when I issue this order, how do you want this to work? You want them to bring a motion? You want me to just do this on my own? Which is basically like saying, hey, when we butcher your cats, do you want us to bury them or serve them to orphans? Tell us which you prefer, because I care about your opinion on this. I care about your thoughts on this, and I want everyone to know that I'm giving you an equal opportunity to weigh in here. So when I butcher your cats, should we bury the corpses, or should we just like leave them hanging on a tree afterwards so everyone can see what happened? You tell me. You tell me what you want. They're your cats, so you tell me. He's not falling for that. And he's like, and Laura's still fighting. He's like, I don't want to start talking about procedurally what will happen when you issue this order. And because he says it's asymmetrical, it doesn't bar Joe Biden from making statements. Joe Biden's not a party for this court. Of course he's not. Of course he's not. Should be. Well, not for you. But yeah. How to enforce? It's impossible. It's unfathomable. Say he wants to criticize VP Pence, says something disparaging. And think about it. He's running against Pence. So Pence should be able to attack him. Be like, I did nothing wrong. Pence will get up there and start saying, you told me that you wanted those rioters to go in there and lop off the heads of all those people, of every member of Congress. And be like, I did nothing wrong. I'm innocent. I did nothing wrong. The only That's what they want. They want everyone to be spineless. You must be spineless before Big Brother. If you're not spineless before Big Brother, nobody has an interest in you. Nobody in the Uniparty wants to have you around. Judge, were there an order? What procedural posture governing enforcement? Meaning, don't sit here giving me your arguments as to why there shouldn't be an order. I'm already pretty much on board with giving this order. You tell me how that's going to happen. Will it be that they're going to that the state will come forward with a motion, or I should do it sui sponte? Laura's not giving in on that, though. I'll tell you this: this guy Lauro, he's a dogged fighter. He's a fighter. Impossible. Can't conceive it. Obviously, we'd appeal it. Ridiculous to think of an order preventing candidate from speaking out on these issues. No limits to the kind of order being suggested, not narrowly tailored, vague, overbreadth, can't come up with better template for violating the First Amendment than prosecutors have come up with in this case. Because if you think about it, the First Amendment, the most important speech that the First Amendment is supposed to be protecting is political speech. According to our founders, that's what they said. Political speech is the most important kind of speech. There's been no threats, nothing that amounts to intimidation. What you put in place is working, frankly. Meaning, you don't need to do anything more. There's been no threats. Everything is working fine. Judge laughs out loud. Politics stop at this courthouse door. At least any politics that disagree with hers. All politics that disagree with Judge Hudkins, stop at the courthouse door. Just stay outside. I don't want to hear any politics that disagree with mine. Kickjack says, having innocent press on talk to the SBF trial. I might. I'll see if I can get a hold of him. What's his name? Lee? Michael Lee is his name, right? I probably can get a hold of him. I'll see if I can. I like your suggestion there. I like it a lot. Gary Manning says Biden's going to join Truth Social. He's spying Trump. Can't wait for the fireworks. I don't think she'll address. I don't think Biden will address Trump directly on Truth Social. I think it's pretty funny. Is Biden really on Truth Social? Let me check that out. Biden Harris HQ is the only thing I see with 12.3 thousand followers. Not bad. Doesn't really look like Biden Harris headquarters when there's really not much about Biden Harris, and it's all about the people in the GOP primary. When it's about Nikki Haley, Tim Scott, and DeSantis, I don't know. I'm not seeing that here. So they have 12.3 thousand followers. Definitely not bad. Donald Trump has 6.43 million followers. Also not bad. Kind of the same thing. Laurel continues. One other thing, the harm being suggested by prosecution or by the Biden administration is completely speculative. No data. Judge says government filed redacted info from people involved who attested to what happened to them. That's not sufficient. Of course not. That predated this case. I like his confidence here. One of the key things about being a good litigator is that you have to be willing to stand up to a hostile judge without being disrespectful. It's a very difficult line to learn to walk. It's a lot of people have passion. You see high school debaters like a moot court type of thing or debate teams when they have these things that they'll be very, very passionate. They don't. One of the things they always need to learn to hone, those who end up becoming litigators, they need to learn to hone how to maintain respect while doing it, and also how to maintain their backbone in the face of a judge who seems hostile to the direction they want the judge to go, and to keep plugging doggedly. And Laura is displaying that in spades here, rather impressively. Because she's been implying throughout that she's planning on giving this order, and it's only a matter of how to implement it. But that this order is coming, and he's not yielding on anything here. And he's making important points here. One other thing, the harm being suggested by prosecution or by the Biden administration is completely speculative. There's no data. And why should we think that there's actually any harm that's been happening here that you need to start issuing orders to restrict his free speech? So she says the government filed redacted info from people involved who attested to what happened to them. Well, that's not sufficient. He says, of course not. That predated this case. Anything that predated the case, what would that have to do with this case? And Trump's not responsible for what some crazed third party does. And that's part of a key thing about free speech. If I'm sitting here today and I'm mocking someone, or I'm saying this person is a terrible human being, and some listener of mine goes out there and says, Joe's right, we need to kill this person, and tries attacking them, that's not on me. I'm not telling anyone to harm anyone. I never want anyone to take my words as an incitement for them to go do some physical harm to someone. That doesn't mean someone won't take it that way. And it's ridiculous to hold me accountable for that. And same is true for any speaker. The same holds true for you. If you say something and your objective is not to try and incite them, but you're just saying something that some crazed person thinks, she's right, we got to do it. And Trump is not responsible for what some crazed third party does. Judge, my concern, jury pool. Her concern is the jury pool. That's her concern, is the jury pool. The jury pool. That they're going to hear Trump say something. And they're going to be like, oh, now I have to find against the state because Trump wrote something on Truth Social. Trump said that Jack Smith is a corrupt piece of hot garbage, which means I can't trust him. I can't trust Jack Smith because Trump said that on Truth Social. So now I have to find in favor of Trump. Like, seriously, what the heck is happening here? So her concern is jury pool, Biden administration, and DOJ. Okay, what's her concern about them? He can't attack his political opponents, special counsel staff, judges staff, and political witnesses. Not discussing this Trump statement. So what's this Trump statement? Where he says, no way I can get a fair trial, even close to a fair trial in Washington, D.C. There are many reasons for this, but just one is that I'm calling for a federal takeover of this filthy crime-ridden embarrassment to our nation, where murders have just shattered the all-time record. Other violent crimes have never been worse, and tourists have fled. Federal takeover is very unpopular with potential area jurors, but necessary for safety, greatness, and for all the world to see. This is very clearly political speech. This is what's bothering her. This is very clear. This has nothing to do with the trial or anything. It's very clearly he's saying this place is hot garbage. It's gross. It's disgusting. It's foul. It's fetid. It's fuming. It's and there's crime everywhere. And the people who are running things now are doing just a stinky job in trying to reel that in. And that's why you need me to come in here and take steps to fix it. But apparently this is something that's no way we should allow him to say that. The fact that she brings this up as evidence of something that needs to be clamped down means that this judge is ill-equipped to be weighing in on a issue of this magnitude. Because if she thinks this is a problem in any way, shape, or form, that means that she has lost the plot about what free speech is. Because this is clearly political speech and is so tangentially, it's difficult to even find the ties. She's going to try and find the ties to how it relates to this trial. But this is the example she gives. Something wrong with her. One, not discussing this Trump statement. Calling DC a filthy, crime-ridden embarrassment disparages the jury pool. Let's assume these statements have affected the pool. How? And what? Why would we assume? First of all, you're a judge and you're saying, let's assume? Without any evidence at all, you're going to say, let's assume this has affected the pool. And in what way would it affect the pool? If anything, in what way would it affect the pool? When he writes that statement, is it so they're going to be mad at him that he thinks that their city stinks? So how is that hurting the state? Why can't these issues be addressed through careful jury selection, Ms. Gaston? Careful what? To avoid the person who's offended by him, the DC resident who's offended by the fact that Trump thinks that their city is basically a hellhole? Gaston, Shepard teaches need to do more. Mr. Laura, do you disagree with that Mr. Trump's statements could be understood as disparaging to D.C.? So Laura says he's disparaging the Biden administration. I would say, I don't care if it's disparaging D.C. How is that possibly an issue that you should be ruling on his right to say that? Why would this trial in any way say that he can't say that all the people who are going to be coming into this jury are terrible people? In what way is that tainting the jury in a way that's unfair to the state? If anything, maybe he's prejudicing himself. Maybe he's prejudicing himself. You can call it stupid. You can call it suicide to do that. Imagine a defendant walks into a courtroom and basically says, then looks at the jury and says to them, and every one of you is a worthless loser. Is that prejudicing the state? Is that harming the state at all? Is that something that we should say, oh no, we know we need to respect his free speech rights, but not that. What the heck is happening here? What is the possible philosophical justification for anyone who has any form of lucidity to actually come forward with a statement that this is something that a court needs to restrict a person from being able to say? Like I said, is it dumb potentially for him to say things disparaging DC? Yeah, it could be. In theory, if he had any shot at a fair trial in DC, it would be a stupid thing for him to be kiboshing that. And maybe his attorney would be like saying to him, shut the hell up, please. But it's still his legal right to say it. Not for a judge to say, no, you can't say something like that. And there's no way that it's tampering with the jury. There's no way it's affecting the jury in which, like, oh, now they can't reach a fair decision and fine for the state. This is the dumbest thing in the world. There's zero logic here. Aggravating. Laura doesn't take that tack. He says he tries reading the statement as he's disparaging the Biden administration. And the judge says that's not what he said. He called the district a filthy, crime-ridden embarrassment. What did he say? I can't even read the tweet. What he wrote here is, I can't get a fair trial in D.C., many reasons, but one is I'm calling for a federal takeover as filthy, crime-ridden embarrassment to our nation where murders have just shattered an all-time record. So he basically is talking, it's amorphous because the second half of it seems like he's talking about literal crime, like, street crime, and as opposed to the first part, which is certainly not talking about street crime, but it sounds talking about DC corruption. So frankly, he seems to be vacillating between the two in one paragraph, which is common for the way he approaches things. But that's part of his colloquialism, which people find endearing. And either way, why is there anything wrong with this? God. Floral from Under the Rock says, Joe, this stuff matters, but you need to have a reprieve and hang with some puppets on a Wednesday night, 9 Eastern, 1 hour. We're a fun date. How do we connect? Okay. That's a new one. Best way to connect with me is probably Twitter. If you drop me a DM, I'm at the following pro. So that's probably the best way to connect with me. That's what I would recommend. England, you're back on YouTube. I thought you were on the other place. Oh, hush. Just stop it. Do gag orders apply to interpretive dance? He's using interpretive dance to say that I smell like foul cheese. So Laura says, I served in D.C., and the judge says, before it became a filthy, crime-ridden embarrassment, laughter. Mr. Trump is entitled to speak out, draw attention to deep problems in this city that need to be addressed, but haven't been addressed by the Biden administration, which is something that I shouldn't even have to tell you, Judge, and yet somehow we're having this conversation. I like that one a lot. Just give me more of these hearts. Plus, These statements, if they had any effect, jurors would likely be biased against Trump, not for him. Yay! Thank you. Yes, 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 yes. Isn't that the problem with censorship? Judge, you keep saying censorship. Why is he saying censorship? It's got nothing to do with censorship. But there's no harm or prejudice to the government that needs protecting, because if anything, he's prejudicing himself, not the government. You keep saying censorship. No question that court is entitled to impose limit on defendant's speech. You see, she jumped on that. That was a mistake. These words here, isn't that a problem with censorship? That's really not relevant to what his to his point that he made here, which is if they had any effect, jurors would likely be biased against Trump, not for him. So she's very defensive about her unchallengeable right to limit speech because it's her courtroom and things are going to happen in her courtroom. He's a rogue judge. Sorry. He was a terrible judge. Really terrible. We're talking about restrictions to ensure a fair trial. Yeah, well, he just pointed out that he's not harming a fair trial if he's kiboshing his own case and alienating himself against the jury, which is what you're basically saying. I wish Laurel would have stuck on that. Instead, he goes to, it's censorship. Would you rather I call it a gag order? It's speech during a political campaign. See, this is not a good argument for him to be making, because you know that she's all about, I don't care about his campaign. That's what she's going to say. But instead, and Laurel keeps coming back to it, and this is the one thing about the way he argues that I don't like, which is you need to understand which arguments she's already shot down, and you can tell that anytime he says it's not fair, his campaign, it's not fair, whatever, and he's trying to run a campaign, and you're wording it that way, you're basically you're giving her the opening to say, I'm not worrying about his campaign in this courtroom, in this trial. I don't care about his campaign. I'm not thinking about his campaign. All I care about is making sure I run a fair trial in my courtroom. So you need to work within that. Effective counsel means that you work within that framework of her mindset if you're going to have any prayer of having success in moving and pushing her in your direction, assuming that she wasn't in the tank before this started, which I know many of us may think otherwise and say that before she sat down this morning, she knew she was going to be issuing a gag order on Trump. And it very likely is the case. But let's give the benefit of the doubt for a moment that perhaps she's mulling over should she issue this gag order or not. And you want to try and maximize the opportunity that you will succeed in stopping this order from going into effect. The only way to maximize that is not to fixate on what matters to you or to your client, but focus on what matters to the judge. What arguments seem compelling to the judge? You know that when you say it's not fair to his campaign, it's not fair to this, that she basically uses that as an opportunity to say to try and plead some sort of moral authority of that she has this virtue that she's all above campaign and politics and elections, and she's all about just running a fair courtroom because justice is blind. And in that being the case, you have to work within that framework and say, okay, justice is blind. You're sitting here, you want to make sure that in our integrity courtroom that the playing field is not going to be harmed. And you need to respect his civil rights, and you can effectuate orders, your highness, that are designed to keep things fair and not tilted unfairly against the government. In what way is him bashing a DC jury or potential juror harmful to the government that's tilted unfairly against them? That's what you need to throw in her face. That's what you need to just sort of throw at her. Not the whole censorship or whatever, because you know that she's going to pretend that doesn't exist. You know she's going to pretend that this is not a political witch hunt. It's censorship, would you rather call a gag order? It's speech during a political campaign. This is not effective. This part is not effective counseling here. I'm telling you objectively. And I like Laura. I think I like his spine, but I don't think that this is. I like his moxie, if not for. I don't really like this argument. So the judge says, if I enter order, he can say Biden administration has neglected the city. That's different from saying it's a filthy crime and embarrassment. So now you're going to start saying that how he expresses, that his colorful language, that he has to talk in a neutered language that you want, Judge. You haven't lost the plot at all. Totally. This totally makes sense. Totally makes sense. We should make sure everyone talks exactly like you would phrase it. And if everyone says things exactly like you would say it, then it's completely fine. Otherwise, you're allowed to stop them from talking. That's what free speech means. And Laurel hits on that and hits it well. This is a good argument for him because he's showing her how stupid her last statement was. So now we're going to have a judge directing the words a candidate can use. And she, like a crazy person, and I'm sorry, I don't like saying this about a judge. Not difficult or impossible task. No, the point is not whether it's possible to be done. The point is you cannot be directing what words, specific words the candidate can use. This is the problem with trying to control free speech. That you're okay with him chastising and saying this place is a mess, but he can't call it filthy and crime-ridden. Why not? Why not? Laura says, candidate cannot say DC is crime-ridden and infested with rats, even though we know that's true. Everyone living in the city knows what's happened in recent years. So Gaston jumps in there. She's the counsel for the state, says, what Laura is saying is the defendant is above the law, not subject to the rules of the court like any other defendant. She's trying to play in here. She knows what the hot button fallback default positions for Judge Chutkan is, and she's basically trying to she's like, let me just hit that button, boom, boom, boom. I'm gonna hit that button now. Let me hit that button so she can jump all over this and side with us. Now, in a transcript, whether it's an official transcript or this sort of rendition here that Roger Parloff worked diligently to get to us, you can't get tone, which is one of the things that's frustrating. He tries infusing some tone, saying this is sarcastic or this is vehemently, and that's good. That's good to the extent he's correct, which I assume he is. I have no reason to think otherwise, but it's moderately helpful. When you're just reading words on a page, it's very hard to know exactly what the vibe in the room is because you can't feel it. And if you can't feel it, when you're seeing why they're saying what they're saying, when they're saying it, it's hard to really get a grip on it. It's very, very difficult to get a grip on it. Something that can be said completely sarcastically can be said with utter sincerity, or vice versa. Something that sounds really sincere could be dripping with sarcasm and really mean the exact opposite of what they're saying. So transcripts are very frustrating in that regard. Now, I'll tell you a quick story here. Quick story. I'm going to sidebar here with a quick story. Quick story here as far as capitalizing on the emotion of a judge. When I was in, I want to say 11th grade. So I had a small class, and we kind of started. I shouldn't tell this story. Never mind. I'm not telling this story. I'm sorry. I apologize. That was really terrible of me. I just realized that it could be embarrassing to someone. I don't want to embarrass them. All right, let's get back to this. The point I was about to share a story where basically I saw someone was exasperated. Like somebody who I knew, I basically spent a lot of time with them, and I saw they were exasperated, and I was trying to control exactly what words they would say. And they were very, very exasperated. They were very, very agitated, and he was all flustered. And as soon as he finished unloading on, so basically John was unloading on Ben, and I wanted John to keep unloading on Ben. So as soon as he finished, I just interjected with like a typical catchphrase that John, who's a teacher, would generally use whenever he was mad. Just because, when he would say, like, so one thing that this guy would say was like, "You're transparent as glass. I can see right through you." So when he was like unloading on Ben and unloading and unloading and unloading, and he finally is like tired and he's worn out from yelling so much at Ben. So like a total snot, I pipe up with like, "Professor, he's transparent as glass. You can see right through him." And he's like, "That's right, Joe. You're transparent as glass. I can see right through you." And the whole class started applauding me. That like I managed, because I was like basically trying to get him to say that phrase. You gotta find the right time and know exactly where, know your target. So she knows her target here. And her target here is Judge Chutkin. And Judge Chutkin loves saying, "No one's above the law in my courtroom. And you think you're above the law." To her, this insecure. And I'm telling you right now, Judge Chutkin, if you're watching this, you are grossly insecure. And I think that Donald Trump himself is really, really insecure. And I think he's terribly insecure. And I think you are so much more insecure. It's frightening, because you're all about like, "This is my courtroom and he's not above here." And you're so desperate to try and show that you're above Donald Trump, because you feel so minuscule in real life that you feel a need to try and show, "I can clamp on the president of the United States because I'm so important." You're so stinking insecure with your whole "no one is above the law in my courtroom" that you're willing to ignore the law just to show that you can wield the law against Trump. You ignore what the law is supposed to be, implement your entire own law just to show that you're the boss. And it's gross. It's disgusting. Frankly, in my opinion, you should be stripped of any judicial power whatsoever. It's gross. I can't stand judges who basically think that the objective there is to make everything about themselves, rather than actually the noble objective of trying to decide things fairly in accordance with established law and precedent. I'm sorry for that little tangent there. He says defendant can't campaign. That's just not true. This order prevents him from using campaign to broadcast materially improper statements about the case. Why? He's allowed to lie. He's allowed to lie whatever he wants. He's free to lie. That's part of your free speech. Free to lie. I don't think he is lying, but even if you think he's lying, he's free to lie. But it's like everyone in this room here seems to have lost the sight of what the First Amendment is all about. The post you just quoted was attacking the jury pool in this case. So it's not. He's basically talking about the awful state of affairs that have been left there by the people who are running things, obviously. But so it's not attacking the jury pool. It's attacking, unless the jury pool are the likes of Muriel Bowser. But I mean, it's just. This is gaslighting to imply that he's attacking the jury pool. And even if he was, so what? How is that harming the government? That's only harming himself. It explicitly says that it's about this trial, Judge. I want to get through all 5 categories. Let me ask you about statements about the Biden administration and DOJ. I have some concerns. Judge, Mr. Trump repeatedly refers to a president as crooked Joe Biden and Department of Injustice. But wouldn't that be casting a broad net? How would name calling affect the administration of justice? Meaning, the judge is now saying to Gaston, "I want you to walk me through why it is that I should try and restrict him from saying that Joe Biden is a thief or a Department of Injustice," which I'll tell you right now is a Department of Injustice. It is. So she's like, "Okay, so give me the legal arguments, Gaston, as to why I should be stopping him from doing that, and because otherwise justice will be harmed." Gaston says, first part, criticizing Biden, example how this order doesn't restrict the order. What? Does crooked Joe Biden violate the order? He does that every day. You're not answering the question. So it does not violate? No. Judge, what about Department of Injustice? So she says, so Gaston says, that does present a concern that Joe will think the DOJ is injustice. It is injustice. So if If you question the establishment, you need to be silenced. That's essentially what she's saying. You're questioning the establishment. So you have to be silenced. You're questioning the establishment. Our concern is not to defend ourselves or the court. It's concerned jury will come to jury selection, not be able to follow court's instructions because of having read these things. Shepard stands for principle. You can't just let this happen up until time of voir dire. Crooked Joe Biden is not a violation, but the Department of Justice would he can criticize Biden to his heart's content. Mr. Trump believes this is Gaston's trying to throw that back to say, see, we're not limiting him. He can criticize Biden. He just can't criticize us. He can't criticize us. No one can criticize us because if you question us, you are questioning the system, and somehow that will make people question the system. And oh my God, we can never have anybody questioning the system. So we need to make sure we silence Donald Trump from ever questioning the system. Good little worker ant, Gaston. Mr. Trump believes his prosecution is politically motivated, but how does that prejudice this proceeding? Seems close to his right to assert innocence and criticize government's use of power, which Court and Gentile says lies close to the heart of the First Amendment, meaning you seem to be running right up against Gentile. It seems to be the Gentile, which is a court decision that we mentioned way at the beginning here, which is one of the two SCOTUS cases which actually reference this issue with respect to restricting a witness's defendant's free speech. So Gentile seems to say the exact opposite of what you're trying to say here, honey, is what she's like. So she's like, do better, do better, do better. Give me something better. Gaston, solutions for Trump to file a vindictive / selective prosecution motion he has said he wants to file. That's not the only solution. The other solution is that he can call attention to your complete corruptness. The judge is struggling to try and connect. Doesn't think that Gaston has connected these dots yet. So she follows up with, so how does his criticism of the Biden DOJ factor in if I enter this order? So Gaston's like, look, you can give him the crooked Joe Biden thing, but not the Department of Injustice. Crooked Joe Biden thing, he's not participating in this case. Defendant can say that. So then Lauro, who sees where he's going, and he's worried that the judge is going to go along with the whole Department of Injustice thing, says, what if Trump says crooked Joe Biden approved this prosecution, which I believe is politically motivated to interfere with the election? Everything here is linked. Gaston says, yes, Your Honor, that violates the order, falsely suggesting Biden directed this prosecution, which he did not. Who cares? First of all, it's definitely not established that he did not direct this. It's not at all established. That is not at all established. You wouldn't necessarily even know if that happened because there'd be a conversation between Garland and Biden. So you wouldn't even freaking know about that. That's first and foremost. Second of all, he most definitely did not. No way he did that. No way, no how. No way, no how. And second of all, why should he not be allowed? Judge says, problem is arguments being made DOJ is under control executive branch. It's part of a campaign. That violates gag order? Gaston says, by the plain language of the order, it would not violate because Joe Biden is not a party participant court personnel. So now we're going to have to walk through every possible iteration of ways that Trump can say things versus ways that he'd be restricted from saying things under this order. This is so insane. It's designed to catch him, to get him to screw up and say something he's not allowed to say. So by plain language of the order, it would not violate because Joe Biden's not a party participant court personnel. Laura says they have to read their own papers before they respond to the court. What if Trump says Hunter Biden is allowed to sue witnesses and allowed to talk and I'm not? We're just trying to struggle with the circumstances of what's being proposed here. I think George Orwell would have a field day with what we're hearing from these prosecutors. And, this is so ridiculously dystopian what they're suggesting here that George Orwell is rolling in his grave. Judge says third category. Judge is just moving on from it. So I don't know so we don't know at this point what she's going to do with this. Seems like she's leaning, I don't know. Who knows? We'll come to it. Judge Third says special counsel on his staff deranged Jack Smith. Refers to his staff as thugs. These statements are troubling. At some point, it goes from permissible criticism to incitement of violence. Really? How? How is that? Who's he inciting? Have you read Brandenburg? Quote, will no one rid me of this meddlesome priest comes to mind. He doesn't say anything about ridding anyone. Public servants doing their job, not just derogatory labels, but highly charged language. You're calling it highly charged language. There has to be some sort of way of interpreting it as him saying that someone should take action about it. If there's not a call for action at all, then to read it as incitement is just mind-boggling. So Laura says Congressman Ford called his prosecutors racist and Sixth Circuit upheld that. Trump is being bullied. I think he said Jack Smith is deranged. He made outrageous statements at the time in indictment linking Trump to violence. So the judge says, in what kind of case is it appropriate for criminal defendant to call prosecutor a thug and stay on the streets? I mean, why should I throw him in jail for calling the prosecutor a thug? I don't know. Why can't you call him a thug? This is the world we're living in now, where calling a prosecutor a thug is a crime. So Laura says, whether it's language, whenever you see L here, that means it's referring to John Lauro. I think his first name is John. His name is definitely Lauro, L-A-U-R-O, and that's Trump's attorney, as opposed to the G, which is Molly Gaston, which is for the government, and J is for Judge Chutkan. So the judge says, I'm asking, in normal prosecution, would defendant be allowed to call a prosecutor a thug? Easy answer on this, yes, definitely. And this is not a normal prosecution. Laura just goes to, this is not a normal case. This is prosecution unprecedented, using statutes in all sorts of crazy ways, take Trump out of a political cycle, asking for an order not just affecting Trump, but the public that wants to hear from Trump. First time we've had sitting administration prosecute a political opponent. Judge, that's not, and this is what I was saying. These are not arguments which will ring well with her because she doesn't want to hear about it. She wants to pretend that that's not what's happening here. Judge says, I heard you say that. You obviously have an audience other than me. I want you to answer my question. Why did you need to use the word thug to describe someone doing their job that wouldn't be allowed with any other defendant? How is the word thug justified? Why would it not be allowed with any defendant? What do you mean? I don't understand that. Why can't any defendant say that? This is like what kind of glass world of fragility is she thinks we're all living in here? Up in CT, how you doing, brother? Don't forget, Chutkan was a judge who let Imran Awan go 1 year probation plus ankle monitor. He was back in Pakistan a week later. She's terrible. She's disaster. Ziddick, how are you? How you been? Wow, this judge want to see you next Tuesday and politically biased. Joe, how do you fix this within the system? I find it difficult. I understand the mental gymnastics she uses to find her conclusions. Well, I'm trying to help you understand the mental gymnastics. How do we fix this? A judge like this, it's hard. It's hard. It's very, very hard. I hit 9K. 9K in the ghetto. And Doug, we did it. You and me, kid. We did it. 9K. Woohoo. It's time to pop. I'll take a shot for the 9K. Been sitting at 8K for so long. So long. So long. And here's to you out in Rumbleland. Joey loves you more than you will know. All right. Moving forward. We got stuff to do. All right. So yeah, I think I don't even understand. I don't even understand the judge's question on this. She says it risks a real possibility of violence. Why? Because he's a thug. So is some gang member going to think, "Oh, he's a thug. I got to take him out." Like, why would him being a thug mean someone has to take him out? This is so stupid. I think she's crazy. I think she's crazy. And I know I'm seeing 899 on Rumble too. I didn't want to. I didn't want to. Ruin things for Nancy there. Nancy was very excited about the 9,000. Don't break her heart. She was very excited about the 9,000. Don't break her heart. It looks like 899 to me too. I know. Very close. Very, very close. I don't know why. I thought I was going to get to 10 like 6 months ago. I was like at 80. I was like at 8,700 6 months ago. I can't like go up a single follower there. God. Yeah, I know it's 90,600 on YouTube. That's because 6 months ago it was 92.6. And they take 40 away from me every day. Bastards. I can guarantee you that by the end of the week, it'll say 92.5. That's what happens. Sorry, I say 90,500. That's what they do. They take away 40. Unless I find ways to like spice up by like making different kind of appearances and things of that nature. So the judge is claiming that the term thug risks a real possibility of violence. Laurel says it certainly doesn't do that. What the hell are you talking about, you crazy person? And he leaves out that last part. What language do you use in a system that's not bordering on authoritarianism? What is the citizen supposed to say when he's denied due process? In presidential Trump's mind, that's what he's facing right now. Judge says Trump tweeted last night he's in Iowa today campaigning, please. Okay. So, but why can't he say thug? Please, Mr. Laurel, let's tone this down a bit. Laurel says it's toned down. As an advocate, I'm entitled to make my arguments on my client. But if Your Honor wants to censor my speech too, the word Trump chose may not be a word you like, but he's entitled to make the statement under these circumstances. Judge says he's targeting Special Counsel Smith's family and wife. So Laurel says wasn't attack on family member. Indication might be political bias by mentioning. So she says by mentioning their spouse. I don't know what she's talking about here. He mentioned Jack Smith's spouse. So Laura says deals with political issues relating to Smith. No orders in place preventing him from saying this is politically biased. Prosecution by politically biased prosecutor. Judge says, what do you feel is appropriate for him to talk about What do you feel is appropriate for him to talk about prosecutor's family and spouse? You telling me that's appropriate and should be allowed? Under the law, yes. It should be allowed. 100% allowed. 1,000% allowed. Why can't I can say if I want to say that Jack Smith's wife is some crazy, terrible human being, even though I have no idea what her name is, or if he's married, I have a right to say that. You have a right to say that. That's part of living in America. Of course it should be allowed. Why are you even asking this question? Are you really a judge? So Laurel says he's entitled to the First Amendment to describe, judge says, in unfettered terms, even if it means mentioning prosecutor's family. Yes, that's what the First Amendment says. Where does it say? Unless it's about someone's family member. How did you become a lawyer, much less a judge? Laurel says it becomes part and parcel of First Amendment, part of reality of being involved in a case of this nature. Assistant Special Counsel Gaston says, I think you identify why government paired disparaging with inflammatory in the order. What defendant's doing is inflammatory. He understands the impact. They motivate others to threaten others in case of witnesses and threatens and chills witnesses. So she's like, by him talking about these people's wives, that's going to scare witnesses and saying, oh no, he's going to go after my wife. And that's going to bother them that they're not going to want to testify. Okay. And September 9/17, meet the press interview. Defendant said false things about one of the witnesses in this case. Also declined to answer certain things, declined to answer questions about his conduct on January 6th. He's able to control himself. He's using campaign to try this case in court of public opinion. Of course he is, because you're trying to use this case to destroy his career. You're the ones who brought this case for the purpose of trying to destroy his political career. So the judge has heard enough about that and says, now turning to statements about court, mentions this one. I was deeply disturbed to learn Mr. Trump made a post about another judge's clerk calling her Schumer's girlfriend. Said she was running the case against me. Mr. L, do you think that's acceptable? That's a little bit. While I do think it should be acceptable, I can understand a judge looking out for their own staff. And this is the one thing I want to say. Okay. Standing in a vacuum. Should that sort of thing, disparaging a clerk of the court, should that be acceptable? 1,000%. 1,000%, in my humble opinion. Would I expect a judge, in perhaps most circumstances, to try and protect their staff from that type of verbal abuse from a defendant, especially one who's powerful and as far as their celebrity status? I would not be remotely surprised. That's one area where judges can be like, I don't want my staff being harassed just because I had this case come in here. This woman works for me. She's been my staff for the last 20 years. And this defendant's going to come here and try and humiliate her in front of millions of people because he's in a foul mood. I'm not letting him do that. So from a realistic human perspective, you can understand an even-tempered judge, not one who hates Trump, but someone who's just very legitimately even, saying, I'm not allowing that to happen. I'm just not allowing him to do that. I'm not going to allow I don't want my staff doesn't have to face abuse just because he decides that he wants to drop it on her for whatever reason. So this is an area that, if there's any area she's going to protect, that's like protecting her own children, because she feels like they're under her umbrella. She's the boss. They're under her. They're part of her camp. So she's going to be naturally defensive on their behalf. And the tweet that she cites is, the Obama appointed judge in the free speech indictment of my political opponent, crooked Joe Biden's Department of Injustice, shared professional ties at the law firm that worked for energy company Burisma based in Ukraine, of which Hunter Biden associates were proud members of the board and were paid millions of dollars, even though Hunter knew almost nothing about energy. How much was the law firm paid? So horrible. I don't think she got the right tweet when she says this. What I assume happened here, and just so you can understand what we are looking at now, okay? So those of you who joined late, Roger Parloff over here was in the courtroom, in the media room, where different members of the media would watch the proceedings on a video feed. On the video feed, they have a split screen into like 4 parts. And one part you see the judge, and then you see the different people arguing, and then they have like an evidence thing, which presumably the judge was pulling up different tweets and saying, what about this thing here? What about this thing here? To address it. And that screen would be something that the attorneys could see, and she could see as well, and the media can see. So I believe that's my speculation, that where Parloff got this particular tweet that he's attaching here is that this is the evidence the judge was showing. But I don't see how this is the right tweet that she's looking for. And I know it's not called a tweet when it's on Truth Social. I just have no idea what they call it there. They probably call it a truth or whatever. So Laura, so L is Laura, who's the judge for Trump, says that's something I believe the judge in New York dealt with. Judge says, I'm not asking that. I advise Mr. Trump not to do that. He knows that there's no way Trump. You can't argue on that one. You can't argue on that one. I advise Mr. Trump not to do that. Would it be appropriate to do that? Laura says, would I tell my client not to do that? Why? Because that's not how, in the middle of the campaign, I guess it was addressed by the judge, but yes, judges are subject to criticism well within the core of the First Amendment. Judge says, why shouldn't I issue a similar order as Judge Engoron did in that case, disparaging obviously untrue remarks about court personnel even after he was on notice? The government was seeking an order limiting extrajudicial statements in this case. So Laura says, no need for an order. If your honor makes that admonition, he'll follow it. I will instruct my client along with what you just suggested. Court dealt with it in New York. It's not an issue here. Debbie says, any question why this judge has been overturned before? P.S. Why is your chat like Berkeley in the 70s tonight? It is? Are you guys being weird tonight? I see a lot of unusual names that I haven't seen before. I don't know what happened. You can go to locals chat, where all the cool people hang. And Mr. K is putting up some disturbing imagery. Disturbing, to say the least. But yeah, I don't know why my chat is weird. I don't know if it's weird. Are you guys being weird? Stop being weird. Be normal, okay? Thank you. Shall we resume now? I want to resume. I got to cover ground. So the judge says you had full control of this court. You've been able to issue orders that have been obeyed and followed. The Shepard case, nothing like that going on here. Your honor is in control. Gaston says, Ms. Laura suggests nothing like that happened in New York has happened here. That's not true. This court has been the subject of criminal threat in relation to this case. Happy to have L admonish his client, Laura admonish his client, but need an order to expand that. Need order expressing clearly on record what's court's order, not expectation is. I think Chad's either drunk or too sober. It's very possible. So, Roger Perloff, if you are new here, you can like and subscribe. I'd be much obliged, by the way. Seriously, truly. Judge now discussing statements about witnesses mentioning posts about Pence and Barr, including this one. Now he's mentioning posts about Mark Milley. Mark Milley, who led perhaps the most embarrassing moment in American history with his grossly incompetent implementation of withdrawal from Afghanistan, costing many lives, leaving behind hundreds of American citizens, and handing over billions of dollars in the finest military equipment ever made, will be leaving the military next week. This will be a time for all citizens of the USA to celebrate. This guy turned out to be a woke train wreck who, if the fake news reporting is correct, was actually dealing with China to give them a heads up on the thinking of the President of the United States. This is an act so egregious that in times gone by, the punishment would have been death. A war between China and the United States could have been the result of that treasonous act. To be continued. Okay, so that's his. Why is any of this a problem? I don't understand this. Roger Parlos continues with now mentioning statements about Brad Raffensperger. So he's a witness in this case, which is why they're going to make a bigger deal about Raffensperger. Judge, let's start with witnesses who are identified but who are public figures. I take your point. Impossible for Trump not to criticize Pence, who's running, but none of the others fit that description. Meaning, why should I allow him to criticize Raffensperger? Oh, I don't know, because we have First Amendment. But so the judge is like, but I have a concern that he's intimidating. So you're saying that these guys are going to be intimidated by something Trump says on True Social? Really? Really? Have you met them? Have you seen any of them? What about other witnesses who are, I guess, public officials and aren't running? So Lauro says, government opportunity to get affidavits from Milley, Raffensperger, Barr. Judge says, why should they have to? Doesn't matter why should they have to. They have. All those men have publicly criticized President Trump. Give as good as they get. Really? Really suggested Trump should be executed? Okay, Trump didn't say that the public should execute him. He says he should be, in times gone by, he would have been tried and hanged. Well, now he's criticizing Milley's conduct and saying Trump had reason to criticize him. Oh, so this is a synopsis from Parloff. So that Laurel went off basically saying how Milley had it coming. The judge says punishable by death. Laurel says what he did say was sort of conduct by head of Joint Chiefs of Staff going around civilian leadership and speaking in China. Judge says why appropriate suggest appropriate punishment is death, writing in all caps death. Doesn't that go too far? No, it doesn't go too far when he's not talking about people doing it. He's talking about that he should be tried for treason. And how is that relevant to anything here? Anything. So how is that relevant to the charges he's being assessed? You're not supposed to be sitting here watching over his language to make sure he's not breaking some new law. How is that relevant to anything here? Lawyer says still true, death penalty for treason. Factually true, not incitement. Judge says that's right up to, will no one rid me of this meddlesome priest? Millions of followers, one of them may act on it. Well, Brandenburg says you're an idiot. The court from Brandenburg looks at you like you're a complete moron, Judge Chutkin. Laura says you hit the nail on the head. Someone took a shot at Representative Scalise. Are we going to say political figures can't give speeches? We're in zone of clear First Amendment political speech, even though there's criminal prosecutions going on. Under Brandenburg standard, it doesn't incite. Well said, Lauro. Well said. Gaston says, we both know Postman Miley was a threat to him and to all witnesses. No, it wasn't. Nobody knows that. Nobody knows that. You don't know that because it definitely was not. If you come after the defendant, he would come after you. We both know that you're a complete liar, Gaston. Gaston starts to defend Millie's actions. Judge cuts her off. That's none of our concern. Judge says, what's the response to Laura's criticism that you didn't provide affidavits from Barr or Millie? Gaston says, of course, prejudice is speculative, maybe chilled in ways we don't know. Well, you know what? To sit here saying we're going to infringe on free speech because we don't know that might have a bad impact is completely violative of every decision the Supreme Court ever gave on this matter, or anything about restricting free speech. God, first-year law student knows this. Gaston says the post about Raffensperger misstated what he said, and it was about exact topic he'd been expected to testify to. The judge says because it concerns subject matter of testimony that government cannot respond to, the testimony should happen in this courtroom, not out in public. Judge continues, Trump is not campaigning against Barr, Raffensperger, or General Milley. Why should he be making public statements about them at all? He's facing felony charges, doesn't get to respond to every statement about him by a witness. No, we should just have statements that they can make about him, and he can't make back. Laura, with respect to Barr, President entitled to describe what he'd like in an attorney general. Compare what Barr did with what an attorney general he'd like would do. Judge says no one has said he can't campaign or respond to criticism. What we're talking about is this language he's using. By the way, I just thought of something about what I was reading earlier that I didn't really address. And that's here. This key phrase that the judge says here, millions of followers, one of them may act on it. All of a sudden now she's remembering that it's Donald Trump and that Donald Trump is a unique person. It's because he has millions of followers that we need to be more worried about statements that he makes. Like this about that punishment, and that it's so egregious that in times going by the punishment would have been death. So this is how the judge is working a double standard in a disturbingly gross way. When it comes to the fact that he's in a campaign, I don't want to hear about campaigns. When it comes about the whole election schedule, I don't want to hear about that. That's not our business. I'm running my courtroom and we're treating all people, and no one's above the law. 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 And I'm not letting your client think he's above the law. No one's above the law in my courtroom. Everyone's treated the same in my courtroom. Everyone's treated the same in my courtroom. But when we're looking at his speech that we should be restricting, we have to remember that because he's Donald Trump and he's special, he has millions of followers, and one of them may fall in line and think that they should actually carry out and go crazy and think that he wants him, that Trump is calling for that crazy person to murder Milley. So the judge now is basically using Donald Trump's celebrity status as a reason to punish him and restrict him and say, we have to be way more careful about what speech we give him, because he's got all these followers, these political followers who are all fans of his. So we have to be very mindful of that. But the judge does not have to be mindful of the fact that he wants to talk to these followers and he wants to campaign. That is a complete and total double standard, which is grossly unfair. You cannot in one breath say that you're not going to be mindful at all of the fact that he's campaigning or that he's special, that he's uniquely Donald Trump, and Donald Trump has to go out there and say things publicly that some other defendants may not need to do. But because he's you're not going to worry about that because everyone's the same. But in the next breath, say, well, we need to worry about this because he's different from everyone else. That is abuse of discretion by the judge. That is where she's displaying her innate bias here. That she's basically using his Donald Trumpiness against him when it's a reason to restrict him, and not using it in his favor when it's a reason to say, hey, we should treat this case a little bit differently. You only treat it differently if it's going to be ruling it against him, and not treating it differently when it's something that he clearly would need because he's Donald Trump when he's trying to run a campaign to try and become the next president of the United States. That's where she's showing her bias. Right here, this tweet right here. Go tweet this. I'm going to forget otherwise. Sorry, give me 1 second. See how long it takes me to write a tweet? Thank you. Let's see how many typos out here. When scheduling trials are considering Trump's needs for free speech as you have Konchak and Right, and we intention damages. Let's shorten that. All right, there we go. What was I at here? Okay, so with respect to Barr, President's entitled to describe what he'd like an AG. Comparing Barr did with compare what Barr did with what an AG he'd like would do. Judge says no one said he can't campaign in response to criticism. What we're talking about is the language he's using. Yeah, because you just don't like his language. You don't like him. That doesn't mean that's not protected. It's protected precisely because people like you exist. That's why there's strong protections, because people like you exist, Judge Hutkin. That's why we need a First Amendment, because the framers were afraid that someone like you would have power. That is why. Can't use words that can be interpreted as threats or attempts to intimidate. So Laura says it's obvious that none of these are threats. I don't think that's obvious. President Trump uses forceful language. That's what he's done since 2015. He's entitled to say things critical of people in the public officials in the political sphere. If anything, this district is biased against the ex-president as a result of the J6 hearings. We're going to be litigating ad infinitum, which is a Latin term which basically means forever. All these issues instead of the case. We should be preparing for a trial instead of these angels on a pin discussion. One simple solution: let's have this trial after the election and solve the problem. Judge says, when Trump has singled out certain people in the past, hasn't that led to them being threatened and harassed? That doesn't matter. That doesn't matter at all. This is such a stupid question. It doesn't matter. Unless you're going to say that he has some cabal of people who are specifically targeting that he's controlling, that would matter. But if just a random person there, a random person here, no, that wouldn't matter. Good. Laura says that's totally irrelevant. Judge says these were people who were doing their job. Several people who filed affidavits and statements threatening them had increased precipitously. Laura says those people are public officials. Election poll workers, no suggestion Trump has ever done anything that amounts to a threat or incitement. People just can't control what other people are going to do. Otherwise, the First Amendment will be excised out of the Constitution. Have tolerated a bit of colorful, vituperative speech. Vituperative is a great word, which basically means like aggressively hostile. Judge says, have to tolerate suggestions of violence. It's not a suggestion of violence. And when he's saying that's what would have happened in the old days, that's not saying someone should go do it today. Gaston says, this is the state attorney, says, Mr. Lauro is saying his client is above the law. See, she keeps coming back to this. She's saying he's above the law. He can say whatever he wants about this case. The statements about Millie Barr Raffensperger were about this case, not campaigning trying to pollute jury pool. Court has obligations to stop it. So in the very same breath, they're saying he's not above the law, but because he's not any more special because he's Donald Trump, but we need to scrutinize his speech, and because, oh my gosh, it's dangerous. He's got millions of followers. Idiots. They don't even see how circular the whole logic is. Judge, let me give you some hypos, Mr. Lauro. No, this will be fun. Bill Barr should be executed for his many treasonous acts. Is that lawful under the conditions of release and permissible? So Laura says, I advise anyone not to make statements like that. Why? I personally, as an officer of the court, that's a tough question. That's a tough question, because does that mean legally executed or that people should do it? That's a tough one. And that's why he's dancing. That's what you got to do in that situation. If you're a lawyer, you got to dance. I personally, as an officer of a court, why? Why would you advise him not to? I don't personally think statements like that need to be made in context out of court proceeding. Judge says, hypo, I hope Bill Barr stays loyal to me or he won't have a place in my next administration. Would that be permissible or an attempt to influence testimony? 100% permissible. Here it's a political statement because it's about trying to get his support in the campaign. Next hypo, Bill Barr is a smart guy, but better learn to keep his mouth shut. 100% legal. Depends on context. If it relates to him Barr arguing Trump and calling him out, fair comment. But if it was day before trial, it would be a different hypo. That's a good call. That's a good call. Day before trial, it's like, you better shut up or you're in trouble. That's a good call. Judge, Bill Barr is a slimy liar and can't be trusted. Permissible? See, by the way, it's good here for the lawyer to answer honestly while still leaning. You have to read, okay, where is she going with this? And you can't just say everything's permissible in this context. I know that's what you would want him to say, but you have to. If he says that, he basically paints himself as someone whose opinion on this should be just dismissed because you're just not thinking through it rationally. So you need to sort of have a little bit of give here, and that's smart lawyering on his part. Bill Barr is a slimy liar and can't be trusted. Permissible? Lawyer says, I'm not going to say truth is defense, but President Trump is allowed to comment on Barr's activity as AG. Bill Barr's a tough guy. Why would that not be? What's wrong with that? Why would that not be permissible? And he says, Laurel continues saying, these are tough-edged political people. Bill Barr, Mike Pence, Millie, Raffensperger used to be tough and rough and tumble. They signed up for it. They're all monetizing their relationship. Do you think anything Trump said prevented them from writing their books? If Your Honor wants to have me show President Trump what your expectations are, I'm happy to show it to him. Gaston says, I'll run through your examples. About Barr being executed, definitely should not be able to do that. Intimidating and threatening toward known witness could chill his testimony and those of others watching. Yeah, right. That's what's going to happen here. I hope he stays loyal. Is intimidating, impinges on content of testimony at trial, potentially violating of conditions of release. Smart guy needs to keep mouth shut, intimidating. This is why they can't be trusted, because their opinion is crazy. That anything he says is intimidating or threatening or harmful or whatever. We've heard this for 7 years from them. Slimy lawyer can't be trusted goes to credibility and potential topics of his testimony. All his statements would cause these individuals to respond in kind. That involves the details of testimony being out in the public outside trial. Government doesn't respond. These statements chill others. What about other witnesses who don't live on military bases and have constant protection? Ms. Laura wants you to just tell him and he'll relate it to Trump so it won't be enforceable. We need an enforceable order. Judge says the address universe of prospective witnesses. Who are these prospective witnesses? Are you talking about 10,000 people you can't talk about? Who are you talking about? So Gaston says witnesses whom defense has publicly attacked are all identifiable in the indictment. He knows they're witnesses. In conditions of release, there's a requirement he not contact witnesses on notice based on discovery. Government has already provided. Slora says courts have recognized that parties to lawsuit involved in a political campaign are to be treated differently. Courts so now trying to say you don't want to treat him special. Well, the court has already recognized that someone involved in a political campaign has to be treated differently. Courts recognize that Ford and Brown cases, Bill Barr is not prevented from speaking out. Judge says Bill Barr is not a criminal defendant. Law says court will be regulating campaign speech. No court has ever done that. This would be a first time. You've asked pointed hypotheticals, but it's not a law school question. What if he says something on a campaign? Are we going to go back here in a contempt hearing? The judge says, we're in here because he keeps calling prosecutors thugs, deranged. That's not a reason to be here, Judge. That's not a reason. He's made comments about court staff and about death penalty for a potential witness. He's made such statements right up to last night. None of these. Death penalty is not a call for, is not incitement. He's made such statements right up to last night. Laura says everything he said is First Amendment protected speech. Gaston says, first of all, the Ford case, court entered what Sixth Circuit called a broad order. And court did it sua sponte, not analogous. With respect to the Brown case, that's a cautionary tale. The court lifted an order restricting defendants' extrajudicial statements. Soon thereafter, defendants started leaking testimony and exhibits, and a new order had to be entered. And that was 2 months before an election. We're much further out. And she says, Judge, thank you. I'm going to take a brief recess. Then she came back and said, after this hearing concludes, I will issue an order setting forth my decision in greater detail. Now sharing the gist of it. I'm going to grant in part and deny in part motion to restrict out-of-court statements. The defendant has sought to represent every statement as part and parcel of his argument that administration is prosecuting on an opponent protected by First Amendment. But there's a right to restrict language that threatens administration of justice. We won't impose limits on the statements about D.C. We'll consider that in a jury selection. So he can talk whatever garbage he wants to about D.C. Won't restrict statements on Biden administration or DOJ. So he can call it the Department of Injustice. Thank you. Thank you so much. I will, however, prohibit all parties from making or reposting statements public targeting special counsel, his staff, my staff, court personnel. Statements targeting family of those people also prohibited as well. This part is not surprising. So she's basically saying you can't go bashing Jack Smith or Judge Chutkan herself or any of her staff. Can't call prosecutors deranged thugs. Deranged or thugs. Can't vilify or incite violence against public officials. I don't think he's ever incited violence. I don't think he's ever in his life incited violence. Also going to bar statements about witnesses or substance of expected testimony. That's where she's... Look, you want to say you can't be talking about certain people? Okay. That is not really that big. Say he can't talk about certain facts that are relevant to this case. That's crazy. In other words, I can understand her saying, these people are doing their job, and I don't want him to have the right to attack them publicly and embarrass them publicly for doing their job. I can understand that, but to say he can't talk about the facts that he's been publicly charged with, that's crazy. Also going to bar statements about witness substance expect testimony. There's real risk witnesses may be intimidated. There's no real risk of that. No witnesses. There's no real risk of that at all. Other witnesses may be reluctant to go forward. Trump can assert his belief that the prosecution is politically motivated, but can't launch smear campaign against participants in this case. No other criminal defendant can do that. He can't either. If participant violates this order, I'll entertain motions by parties or sua sponte to consider sanctions. Court is adjourned. And there you go. So, and Parloff here wraps it up with saying, in sum, Trump is permitted to talk about Ramfest in D.C., crooked Bojan, Department of Injustice, but he can't attack individuals, like Jack Smith, his staff, court staff, and it should go without saying their families. Finally, he can't discuss or attack expected witnesses or characterize their expected testimony. She did not mention what sanctions she imposed in case of violation, except to say she should entertain motions for sanctions. They rarely will say what sanctions they're going to give before an event happens. They usually want to reserve that and keep that as the sword of Damocles that you have no idea how hard it's going to fall. It's very rare for them to actually say, if you do this, I'll give sanctions in this amount, it's just rare for them to do that. Is Nick streaming? I don't even see him streaming. I wanted to redirect you all. I was trying to set that up. Nicholas! I don't see him. Sua sponte, as I mentioned earlier, I should have when I was reading the final decision of the court, I should have given an explanation of that. It just means of the court's own initiative, like basically think spontaneous combustion. So they can be walking. Normally, whenever anything happens in court, there's a motion. Formal papers are filed by one side or the other. So in this context, it would be Gaston here filing a motion saying you said he can't talk about Jack Smith, and here he is bashing Jack Smith. So please issue contempt order against him or whatever. Hold him in contempt, fine him, whatever it is. Or sua sponte means the court of its own initiative, without someone bringing a motion, can just say, hey, I'm decided that I saw this tweet that he sent out, and I think that's violating my order. I'm issuing sanctions against him right here and now. No one even had a heads up notice about it, but I saw it, and I'm following up on that. Why don't I see him here? He is streaming. Let's see. I don't understand this. I don't understand what's happening here. I don't understand this. He's live on Rumble. I don't understand that. You tell me read rants, and I don't even see any rants. Oh, sorry. Doubt me again, Joe. LOL. Congratulations. Now let's get 10. I may have to refresh. I think I might have to refresh. Upon the Horizon was confirming 9K. God bless you all. Bildo says, yeah, 9K now. Congrats. Thank you. Thank you. I don't know why the wasn't showing for me. It wasn't showing for me. Well, good job, Rumble. You guys rock. I don't see him here on YouTube, but I am going to let you. Supposedly he's over on. Let me do a quick look, see if it's just not showing for me for one reason or another. I'm very curious about this. I need to know. Let's see if. He is live. Why can't I don't understand why I can't. This doesn't make any sense. Why can't I move you over there? Look at this. When I try redirecting you, I want you to see what I'm looking at here. Check this out. There's a list of all the places I can send you over to. Say MLS, Sword and Scale, Runkle. These are upcoming ones. Even when I put in Ricetta, nothing. Oh. All right. There you go. That was weird. Okay. Well, now you're on your way. I'm on my way out of here. Sending you down. I will be back here, God willing, tomorrow evening at 10 o'clock. Till then, I hope you all take care of yourselves. Look out for your loved ones. And as always, Beak Boop says, you're stuck with us, Joe. Sounds like you have to keep going. And Trigger seconds that. I do not. I don't have to keep going, my friends. I'm signing off. Take care and Godspeed.